let's go to 155, People versus Gary. Counselor, you want any rebuttal time?
3 minutes, please.
3 minutes. Go ahead.
May it please the Court, my name is Erica Dubno, and I represent the defendant appellant Alfred Gary. At the outset, I just want to say that Harold Farringer, my partner, was supposed to argue this case. He passed away this year. Unfortunately, he couldn't be here, but he was looking forward to seeing you here. Okay. One of the most cherished policies of this nation is that a defendant has the right to confront the witnesses against him. Obviously, that's protected in the Sixth Amendment in Article I, Section 6 of the New York State Constitution.
But didn't you agree to all this stuff coming in, though?
Initially, yes, that is correct. Initially.
So what do you mean initially? You agreed to let it in. And couldn't you have stipulated it all in unless or except so-and-so was the case?
Well, that's exactly what happened. In this case, because there were two versions of the document, one containing the handwritten notation and one without it, counsel stipulated everything into the record and didn't realize that the version with the handwriting had in fact been admitted.
But didn't you let a witness testify concerning this note and the handwritten comments and go through his entire testimony and cross-examination and not object?
Up until the last part, that was correct, Your Honor. He did, in fact, trial counsel did, in fact, allow the statement to come in, the handwritten notation on the bottom, and he said later on that it slipped past him and he missed it. He did, however, immediately object to it the next day when he realized that that was the version that was in evidence. At that point, which was only the second day in a 2-week-long bench trial, trial counsel moved to strike the handwritten hearsay at the bottom of the document.
But you're conceding that counsel did receive both documents. You're not suggesting he didn't get both.
There's no question.
He stipulated to both as part of all of the documents he stipulated to, correct?
Yeah, there were 150,000 pages of Rosario.
Good, but he stipulated to all of them. So then at the trial, he's got a witness testifying about that document. He knew he had stipulated to it.
And, Your Honor, he admitted that it slipped past him. The next day.
What about the documents from Countrywide, the servicing documents that were also stipulated to that apparently had the same information as was at the bottom of this Exhibit 17C that trial counsel said got by him?
The servicing documents did not, in fact, have the same identical information at all, and they were not nearly as devastating and damaging as the hearsay statement. The servicing documents, which are in the RA at 11 to 17, those documents don't say that they spoke with Al Gary. What they say is they have a phone number there, and they say they list some information there. It does not say that they ever spoke with Mr. Gary, whose name is Alfred Gary. It was the handwritten notation that says 1/12 spoke with Gary, and that was what was so devastating. And the reason why that was so devastating is that the verification of the verification of employment form itself really was not a basis for anyone to have convicted Mr. Gary. That information had the wrong name on it. It was signed Alan Gary, not Alfred Gary.
Can you clarify something for me? Was there only the one verification of employment form here, or were there more than one? I thought that there were 2 or 3 of them.
In the record, there was only one verification of employment form. The prosecutor's cooperating witness testified without any documentation to corroborate it that there were 3, that he said that it 3 times. He never indicated when those verifications were done, and the fact that
and then there was the testimony that they were sent to him with instructions to send them back, correct?
That was his allegation. In this situation,
right, that was the testimony.
The testimony was that
the fact that the form itself, even without the notation on it, says what it's for and what the penalties are for submitting a false one, that all would have been in evidence anyway, correct?
The form itself, we were not contesting the admissibility of the verification of employment form, the one verification that was introduced into evidence.
But I guess I'm saying that together with the other testimony. Isn't that enough to?
Not at all, Your Honor. If you look at the verification form itself, on its face it has the wrong company name, the wrong the defendant's name is wrong, his title is wrong. There's no
that it was faxed from his fax.
That's correct, Your Honor. There's a fax line across the top. However, the only testimony in the record on this which is at 1170 in the record, the testimony was that other people had access to the fax machine. This is a situation where you're condemning a man to
But there's no evidence that anyone else had a connection.
there were people.
Pete and everyone else, right?
There were people in and out of his office all the time. It was a common area, and so that it was possible other people could have sent the
But
fax.
clearly, the defendant is the one who's getting money from the players.
The defendant did not, in fact, receive any money for the verification of employment forms.
I understand I understand his position, but certainly the government is putting forth evidence that he is getting money off this sweet deal. I understand your argument, but it's not like there's no evidence that somehow connects him.
But the issue here was, because the conspiracy, if you actually look at the conspiracy charged in count 2, it was for the production of false documents. And so that was really what they were focusing on.
Isn't this going to the credibility?
The credibility
This
of
evidence, isn't it the trial judge who's observing the witness who's making a decision about the credibility, about what he says or doesn't say happened? And it's basically your client saying, they're all lying, and I didn't do this.
This was not really a credibility issue. What this was the only document or evidence to corroborate
What
the
kind of
witness's
rule?
testimony.
Let me ask this. It's two things. What kind of rule are you proposing that we would apply where counsel had time to prepare for the case, 4.5 months? I think they gave him an adjournment to do it. He gets ready for the case. He comes in. They agree to a stipulation on the record. They waive any objections to the documents. They're waived in. There's no objection when the document is put in. It's not done until the next morning. As I understand it, you're proposing a fairness demands objection that's preserved post-waiver of rights. Is that correct?
In a situation such as this, where you have a bench trial, and I think that that's the most important thing here, is that it is a bench trial, that in a situation where you can cure any kind of harm, the witness was still on the stand. He had not even begun his
So
cross-examination.
you're saying if it was
at
a
that
jury
point.
trial, it would be different because they wouldn't be able to ignore the evidence, but in a bench trial, the court would be able to?
That's certainly one factor there. The second factor is that with a jury trial, you have pressing time demands, whereas here, this case was strung out over a 2-week period
What
of
I'm
time.
trying to do is articulate in my own head what this rule would be, and it seems to be anything like I articulate would be an impossible rule to apply and still preserve the right to stipulate documents and evidence.
That a stipulation would be binding unless a defendant can establish within a period of time where they can cure, recognizing that sometimes thousands of documents come in, you stipulate. That's the whole point of stipulations, is to make life easier. But sometimes stuff slips by.
What if the witness was no longer available?
In this situation, the witness was available. There are cases, the DeMoro case that was decided by the court, in that case, the witness was already off the stand. But in this case...
Well, it's even more serious. To follow up on Judge Stein's point, what if somebody passes away? That's, in a civil case, that's very common.
And in that situation, you wouldn't be able to have...
So it would be an abuse of discretion standard. It wouldn't be, you weren't really waiving it. The court could review it then.
The court certainly had the authority to review it. The court, he was there, the witness was there on the very first, it was the second day of trial. It was a strung-out, long bench trial. The prosecution concedes that they could have called the witness. We could have been able to confront the witness who wrote the handwritten notation. But at this...
Judge Abdus-Salam.
I apologize.
Last question.
I was just going to say that might have been ideal, and perhaps, you know, some other trial judge would do it, but aren't we looking at an abuse of discretion standard here? And would we call this an abuse of discretion? Because the judge did say, if it hadn't been for the testimony that came in, I might have a different ruling.
I believe in that case, the judge may have believed incorrectly that he didn't have the authority to make that determination. I think he thought that the rule was that you have to have a contemporaneous objection, and because a day had gone by, you're correct, Your Honor, a day had in fact gone by, that the judge was now precluded from making that determination. The witness was still there. The witness was on the stand.
Counsel.
Thank you, Your Honor. I
Thanks, counsel. You'll
appreciate
have your
it.
rebuttal. Let's hear from your adversary.
Good afternoon. Good afternoon. May it please the Court. My name is Jason Richards. I represent the respondent in this matter, people of the state of New York.
There were an awful lot of documents going in here, counsel, weren't there?
Yes, there were. But this particular document
Are
was
they held to the nth degree for all these many documents?
There were many documents that were stipulated into evidence, but this was among the most important. It was one of the few documents that had the defendant's name on it, and that's...
He got acquitted of everything except one charge, right?
That's correct.
Would it have been an abuse of discretion if the trial court granted the motion?
Arguably, yes. I think it would have been, insofar as the court would have been holding itself not bound by the party stipulation.
Well, that happens all the time. And you know, what struck me, one of the reasons why I granted leaving this is that I do mostly civil work. But the number of hospital records that go in, and all of a sudden you say, Judge, I didn't realize that there was a chemical test that, you know, unrelated to what I'm, you know, I want that redacted. Of course. You know, I'm surprised someone here didn't say, fine, you didn't stipulate to it, we're moving it in anyway. And move it in through a witness or something else. And you don't need the stip. But the judge seemed to be saying, you know, well, you stipulated it in, you're frozen. And I think that's kind of a tight straitjacket to put a court in, don't you think?
I'm not sure that's what the trial court actually said. My reading of what the trial court said was that had defense counsel made a prompt objection, that the motion to strike would have been entertained. But because he waited a day, and he waited until after the evidence had been, the arguably objectionable evidence had been testified about extensively.
Did you? I know you didn't try the case, but was this a surprise to both sides? Because the stipulation seemed to be referring to the verification of employment. This is a verification of employment plus a note that was underneath Exhibit 17C, and the argument could, you know, it seemed to me that 17C is the VOE. It's not the note that whoever put it on there, because as your opponent is pointing out, the name is wrong, the name of the Capital Finance is wrong, the dates are wrong. I mean, this looked like a phony document, and I'm just wondering if, you know, the judge think, you know, can't do anything about it now. It's too late.
Well, there was no surprise. The document was marked for admission as Exhibit 17C, and it was stipulated to be admitted as such, as it was. So there was no surprise from the people's perspective. As far as the spelling of the defendant's name goes, the only evidence that it was misspelled or that it wasn't his signature came from the defendant himself, and as...
Well, it says Allen.
Yes.
I think, couldn't you take him at his word that his name isn't Allen?
The only evidence at trial that he doesn't go by that name was from his own testimony, and that he didn't sign it.
Do you honestly think that everybody called him Allen and his real name was Alfred?
I think it's possible that he signed it Allen for whatever
No, he
reason.
signed, well, he printed his name A. Gary, I guess. I don't know, it just seemed to me that it would have been an easy thing to say, fine, it's not stipulated in. Counsel, do you want to make a motion to admit it based upon whatever the people had to support that admission?
Well, the people relied on the stipulation in planning their trial and planning on which witnesses to call.
But suppose the document should not have gone in. Suppose it was a document, you know, wholly unrelated. It's his child's birth certificate. And he says, I don't think that ought to be part of the record. I overlooked it, sorry. And the people say, oh, no, it's going in. We're going to prove that your kid was born on St. Patrick's Day. What's the harm to the people? I mean, why wouldn't they say, okay, you didn't stipulate, you overlooked it, fine. Judge, we're moving it. It's part of the record. It's critical to our case. It's a VOE. This is the whole point. And we want it moved into evidence.
Your Honor, that's not this case. And this came up in the context of a motion to strike. So
yeah.
The issue is whether the court abused its discretion in denying that motion to strike at the time when the motion was made.
Do you understand my point? I mean, I'm missing why two lawyers in a courtroom where one says, I made a mistake, I didn't mean to stipulate that in. The other lawyer would have said, got it. Judge, it's not stipulated in, but I'm moving it in anyway because it's germane, it's relevant, and it's part of the record. And the judge would have said, it's in. And we wouldn't be arguing over steps.
I think that wasn't done in this case because there had been a stipulation and because the defendant was not timely.
I guess you don't see my point. I'm just wondering why. You know, a judge wouldn't say, okay, you made a mistake. I don't believe you made a mistake. I think you're lying. No, I think what he said is you didn't catch it fast enough. And as silly as it seemed, I just said, what are we doing? I mean, why can't we say, well, if the lawyer makes a mistake, we let it in, or don't let it in, and then you could make your appropriate motion to admit it. Mark it and admit it. She's making a confrontation argument, for goodness sake. You can get around that in a heartbeat.
I think that in the context in which this came up, there had already been reliance on the stipulation. So if...
By reliance, you mean they didn't have a witness to back it up?
Exactly. Exactly.
Yeah, we live in an imperfect world, and that's the real reality here. But really, and as a practical point of view, all the time in civil cases you have information that's included, particularly in hospital records, about people's lives that are let in and not redacted by mistake that you want to correct. And here, this is clearly a relevant piece of information, so you would have just brought somebody in to do it, but you didn't line somebody up, so that's why you relied on this?
Yes, that's correct.
Did you make that argument?
We made the argument that the witness was not a... do you mean...
Yeah, that but for the fact that there was a stip here, you would have had a witness, and now you've lost him or her and don't have it, and therefore...
At trial, no, I don't think that argument was made, but there's nothing in the record that this witness, the witness who would have come in and testified about the significance of the handwritten note, was in fact available for trial.
Oh, counsel, if I could just ask before your time runs out. You started out saying this is an important document. It's the one that has his name on it. So why do you all argue alternatively it's harmless? How is it harmless if we agree with defendant that this is error? You're saying it's such an important document. This is the one with the name. It's almost like you're saying it's a smoking gun.
As was mentioned before, the document without the handwriting on it also came in, and that in and of itself, combined with the testimony of Carlos Arizari, established that the defendant had committed this fraud. The handwriting was important, but it wasn't unavailable from other sources. It also came in through the servicing notes, and that's why this...
Well, your adversary says that his name wasn't on the servicing notes. There was a phone number only, and the phone number might have been to the dealership, but not his name.
There was a phone number, and there was his name as it was signed on the Allen, Gary, I think. But yes, his name was on there, Gary, and his phone number was on there. And there was also a certificate of incorporation that was faxed from his fax number that was included in the servicing notes. So,
but the note didn't say I spoke with him and he verified this, right?
There's a box to check that says verified by speaking with or something along those lines. So the box was checked, the number was listed, the name was written down. And
just so I'm clear, though, your argument isn't that stipulation one, stipulate forever, and you can never do it. Your argument is that it wasn't an abuse of discretion for the court not to do it,
That's
right?
correct. That's correct. I'm not saying that in all cases where a stipulation has been entered that there's no room to revise it. But in this case, where the objection came in the late manner that it did, under the circumstances that it did, it was not an abuse of discretion to deny the motion to strike.
Thank you.
Okay, thanks, counsel. Counsel rebuttal?
Thank you, Your Honor. At the outset, it is indeed a dangerous precedent to say that not catching something fast enough is a basis for someone's conviction. The prosecution concedes that this was among the most important documents. They also conceded at oral argument in the appellate division that the witness could have been called. There was nothing in the record saying that.
Well, what if it was caught even later? What if it was caught on the last day of trial? Would your answer be different?
As long as, especially in a bench trial where it's easier to put things out of your mind, as long as it's in a position where the prosecution or the other side is not prejudiced by the delay in catching an error, then it shouldn't matter, because the reality is things happen. It's a human enterprise.
Yeah, but don't you have any obligation to limit your stipulation to say, stipulate subject to objections for hearsay or whatever it might be? I just, okay, let him in, you know, is there any obligation on your part?
No, there's no question counsel had an obligation, but in this situation where you have two versions of the document, and he said on the record that he was confused by it, which one was going in, and there was absolutely no prejudice to the prosecution, they could have called the witness.
So it's an abuse of discretion by the judge?
I'm not sure it really is an abuse of discretion, because in this situation, the judge admitted that he would have decided otherwise.
It's an abuse of discretion.
But I think he felt like he was obliged to do so, because I think he thought the rule was you had to have a contemporaneous
You're
objection.
saying he made a mistake rather than abuse of discretion?
I think it was a mistake of law.
Yeah.
It was an error, and I think that
I'm sorry, counsel, it sounds to me like from the record that the judge decided that because there had been testimony regarding the document, that was the reason that he wasn't striking it, because the testimony had already come in.
the testimony was only the testimony. He had only been examined by the prosecutor, and he had not, in fact, been cross-examined by the defense attorney on this issue yet.
But it came in without objection.
It certainly came in with an objection, but the reality is, as Judge Fahey asked, what the rules should be, and I think probably the rules should be that in a bench trial where there's no harm to the other side, and any kind of prejudice, any harm, the error, can be cured, that a stipulation can be revisited and the court is not bound by it. Thank you, Your Honor.
Okay, counsel, thanks. Thank you both. Appreciate it.